morning to everybody. My group will talk about discrimination against pregnant women in military secondary education. My name is José Sotomayor Vargas, and I start with a question. Is it tolerable that in constitutional country of right and justice that is still discrimination against pregnant women? According to the International Labour Office, motherhood is a state that requires different treatment in order to respect true equality. And on this way, it is more a premise of the principle of equality than an exception to it. A special measure must be taken to protect maternity so that women can fulfill their role as mothers without being marginalized in the labor market. Article 43 of our Constitution guarantees pregnant and lactic women the right not to be discriminated against because of their pregnancy in educationally, judicially, and labor spheres. The Constitutional Court seeks to protect the rights of pregnant women and seeks to guarantee their protection by means of sentences that have become mandatory for each similar future case in example sentences number 1894-1020, which is the research in order to explain and non-discrimination to pregnant women. This is easy. We'll talk about the history of the trial, the sentences to the Constitutional Court, and the impact of the sentences in the Ecuadorian society. My partner will talk about the sentences of Constitutional Court.
Good afternoon, my name is Anthony Chavez and I am going to talk about the first body paragraph. Well, the facts that happened in the judgment numbered 1894-10-JP20 were determined in the result. First, the name of the applicant is Tatiana Coronel Silva, was separated from the military school by the fact she was pregnant, which was proven by the examination conducted at the military school polyclinic, which tested positive. Second, a trial was held to determine the disciplinary misconduct she had incurred and also to exercise her right to defense. Third, in this trial, it was decided to adopt Jessica Coronel immediately separation from the military school. Fourth, the applicant who proceeded from the decisions against her decided to bring action for protections because she believed that different rights had been violated. Right. Such as not being discriminated against on the basis of being pregnant in education, social, labor, and she also alleged she had been violated due process. For this reason, she demanded her violated right be restored.
The sentences of the Constitutional Court has a powerful role in the law. The sentences must be compulsorily fulfilled throughout both Ecuadorian territory. The sentences dictate that the Ministry of National Defense and the Joint Command of the Armed Forces enforce the right of the pregnant woman and men in a state of paternity so that these people can be admitted to military school and college and be admitted to the labor area of the military force. These sentences clarifies that the institutions relate to the military force as other institutions must ensure the safety of pregnant women, applying necessary measures to comply with said security.
Is the social impact of women. The women, the social impact is very important, the role of the history of society. For a long time, the women struggled to be included in political, economic, and educational life. Obtained to write the vote in 1929, before any other country in the region. More unlike what happened in other Latin American nations. This took place without the action of a suffragette movement. American nations, this took place without the action of suffragette movement, but despite this achievement, their increasing economic to over a third of the workforce, and their educational level have increased considerably. Although they are still evident, not long ago it was very real to see how women in gestation were freed from their work because they are the victims, the ultimate dismal, not only the workplace but also in educational area. In the same way, the fact is very palpable reality among young people and adolescents in many schools. The idea of the achieving inclusions of the adolescents who are pregnant, no yet respect science being proven that the state of pregnancy and really the pregnancy no is limitation for the women to develop in the different area. The conclusion my group is ensure the lack of application of the constitutional law in military schools in the educational and labor area caused the right of the people in the state of maternity or paternity are warrant this sentence having in the form of the law should be applied in the future case.